Hello to all my valued app subscribers. Today's practical help topic has actually been on my mind for some time, but yesterday I had to point out to someone again that what he believed to have been his water use license was in actual fact nothing more than an entry in the country's water user database and not vesting him with any rights or permissions to use the water in question. So in this presentation I'm trying to clarify the confusion that has been caused by different registration processes promulgated in terms of the National Water Act over the years. Okay, so let's unpack the two registration processes that are causing the confusion. But before doing so, just a little bit of background. In 1998, when the new National Water Act came into effect, the then Department of Water Affairs and Forestry unfortunately did not inherit a detailed and comprehensive database of water users in the country. Now, the reason for that was the fact that the Act's predecessor, the 1956 Act, only regulated a handful of water use, whereas the 1998 Act set out to regulate almost all types of water users as defined in Section 21 of the Act. So for the department then to identify who had to apply for some type of an authorization in terms of the new National Water Act, they obviously first had to identify water users in the country. And to this end then they published two government gazettes during that period in which they called on specific water users to register their water use with the Department of Water Affairs and Forestry, as they were called at the time. They also made available prescribed registration forms for this purpose that had to be used and that are still being used today. Now, the objectives of this first registration drive included the provision of information on water use patterns in the country, both lawful, unlawful, as well as previously unregulated. And this information would then form the basis for supply and demand management, as well as the identification of licensing requirements for certain water users. Now, I suppose, as could have been predicted to some extent, this registration drive was not very effective. Not many people responded, and those who did were mostly companies, and they were issued with registration certificates. And these certificates were mainly mistaken by the companies for water use licenses. And till today, many companies operate under the misconception that their water use is licensed, whereas it is merely registered. Now, this registration process one can compare with the census. It was a type of a water user census and nothing more than that. Now, because this was not effective, it really was a huge obstacle in the management of our water resources since 1999, and the department decided to repeat the exercise in 2023. So the 2023 registration attempt again consisted of two government notices. The one called on users to update their 1999 details, and the other one to re-register certain water users. So the first one, 3137, was the instruction to update the 1999 registration details by submitting a written application for amendment using prescribed forms for the following users. Now, this had to be done on or before the 10th of June, but the department is still receiving late applications as part of their bigger initiative of trying to get a grip on the water users in the country. So people taking water directly from a water resource, such as a river, spring, wetland or groundwater, must update the 1999 details if it has changed. People storing such raw water update details, and people undertaking commercial forestry, being our only declared stream flow reduction activity, must register as a Section 21D water use. Now, just bear in mind, if you take water from a municipality, that is not taking directly from a water resource. The municipalities will register as taking directly from a water resource, and therefore the users serviced by the municipalities need not also do so. Now, if you're undertaking one of these water uses, but you have not registered it in 1999 as required, or the use started after 1999, then you must still submit an application for registration and to get these users onto the Central Water User Database of the department. The second notice, GM 3138, specifically related to waste-related water users, and here the instruction was to re-register and not to update the 1999 details. The reason for that being the fact that most of the 1999 registration information for these water users have been lost. So the department is starting from scratch, so to speak. Now, the water users that had to be re-registered, firstly, Section 21E, engaging in a controlled activity defined as such, in terms of Section 347, with specific reference to irrigation of land with waste or water containing waste generated through any industrial activity or by a waterwork. So, spraying of wastewater onto any land triggers this re-registration obligation. 21F, discharging waste or water containing waste into a water resource through a pipe, canal or other conduit. So this is your typical controlled discharge through a pipe into a river, spring, wetland, or a drainage channel that links up with the river. So re-registration required for all these water users. Section 21G, disposing of waste in a manner which may detrimentally impact on a water resource. This would typically be your waste rock dumps, tailings dams, and any other waste that are deposited in a way that could impact either on surface water runoff or on groundwater through seepage and leachate. Section 21H, disposing in any manner of water which contains waste from or which has been heated in any industrial or power generation process. So again, this is very broad. A disposal in any manner of water which contains waste or which has been heated in any industrial or power generation process. Now, by such a broad reading, it includes wastewater disposed to municipal wastewater works, but you will see that water users that are listed in the first schedule to the National Water Act need not be registered, and discharges to municipal wastewater works are listed in the first schedule as a water use that need not be licensed, provided that you are authorized to dispose to the municipality and that they in turn are authorized to release their water into a water resource. So the municipal discharges to municipal wastewater treatment systems need not be re-registered as a Section 21H water use. Section 21J, removing, discharging or disposing of water found underground if it is necessary for the efficient continuation of any activity or for the safety of people. So if you take groundwater for use, then it is a Section 21A abstraction. If, however, you remove water seeping into your basement or into a quarry, that you don't really want the water, you don't really need it, but you have to remove it to continue your operation safely, then you re-register that particular use as a Section 21J use. Right, so important to check your water abstraction for small domestic purposes, livestock watering and so on, fall within the ambit of Schedule 1, which need not be registered, but for the rest you carefully need to consider your re-registration and updating obligations. Now, water users falling under the area of operation of a water management institution or a water user association, they were previously called irrigation boards, or government water schemes, should submit their application for re-registration directly to the water management institution and not to the Department of Water Affairs. So let's have a look at what the registration certificate looks like that the department issues. You'll see from the heading there's already an indication that this is a National Register of Water Use registration record with a unique registration number. Now, before I point out certain relevant entries to you, just want to show you the disclaimer at the bottom of the cover letter. Now, I'm not sure why the department puts this in fine print and not in bold, large letters, but in any event, you'll see that it's stated expressly here that this registration record is not an acknowledgement of an entitlement to the registered water use. So the department does not confirm that you're entitled to the use. It may not be used to create the impression that it is proof of a water use entitlement. By virtue of Section 22(1) of the National Water Act, the only documents that may be used as proof of a water use entitlement are either a license, an official document stating the extent of existing lawful water use, a general authorization as published in the Gazette, or a Schedule 1 of the National Water Act. And then if we look at the detail, the form captures all the personal details of the applicant and the water use. So there it is, the water management area. It's active now on the registration database, so it has been registered. These are the details. This is a Section 21A use of 14,400 cubic meters per year. And what is then important for our discussion is this section, lawfulness authentication, and you will see that the department indicated lawfulness still to be determined. So again, this emphasizes the fact that this certificate does not reflect anything about the status of the use. This use might just as well be unlawful. We can't tell from the information. Additional investigation is required to see whether this user qualifies for any of these scenarios that would result in a lawfulness verification. Right, so this is what the 1999 forms looked like, as well as the repeat of that exercise in 2023. Great, so you're now in a position to pull out your water use registration certificates and to check whether it is the type that only adds your water use to the national database without giving you any indication as to the lawfulness of the use, with a specific qualifier at the bottom of the page alerting you to the fact that the certificate does not constitute a license or a permit or any type of a confirmation of your entitlement to the use. That brings us to the second type of registration, and that's the one that's been causing a lot of confusion as well. And it is the registration of water users that have been generally authorized by notice in the Gazette. Now, what does that refer to? Let's just quickly get some background on generally authorized use. All water users that are listed in Section 21 of the National Water Act must be licensed unless they are listed in the first schedule to the National Water Act, or they are recognized as existing lawful use, for which an extensive definition is contained in the Act, or they have been generally authorized by notice in the Gazette, or the license requirement has been waived by the Department of Water and Sanitation. So if we cannot satisfy any one of these circumstances, then the water use requires licensing. Now, the generally authorized use is the topic of the second round of registrations, in that most of these generally authorized uses must be registered just to confirm that it qualifies for general authorization. We are going to look at the generally authorized water use, and I'm highlighting the paragraphs in these authorizations that require registration, and then we'll talk through those topics. So most of the Section 21 water users have been generally authorized under certain circumstances, and these circumstances relate to geographical areas, types of industries, quantities of water, and quality of water. So the idea is to exempt relatively small water users from the rather extensive and expensive water use licensing process. So to determine whether one qualifies for any of these generally authorized water use, you need to very carefully study the general authorization or the gazette in which the authorization was published, and then to ensure that you comply with the conditions. So it is not an unconditional exemption from water use license requirements. You can see it as a type of a glorified license for which you don't have to apply, but you must comply with all the conditions. And included in these conditions is an obligation to register your generally authorized use. Now, the reason for the registration is for the department to be aware of your water use and to be in a position to monitor your compliance with the conditions. If you do not register, they do not know about you. And then they're back in the situation where they have a database, but they do not have a grip on who is using water legally and who are unlawful users of water. So you'll recognize most of the Section 21 water users in the generally authorized use, but as I said, each of them subject to specific limitations that you must study, and not assume that all of these users automatically qualify for general authorization. The general authorization notice numbers here for taking and storage is GN 538. If you qualify for the authorization, then you need to register both of those water users. If you impede or divert the flow of water in a watercourse, for example, if you build river crossings or culverts and you divert the flow of water in a watercourse, then there is a general authorization, difficult to interpret. They are contained in 2 government notices, and both of them require of you to register the use if you believe that you qualify for the general authorization. If you again irrigate land with water or waste or water containing waste, as within the water quality limits that the general authorization impose, you must register in terms of paragraph 1.8. If you discharge water waste or water containing waste into a water resource, pipe, canal, sewer or other conduit, again within the quantity and quality restrictions and the geographical areas permitted in terms of this general authorization, then you must register it in terms of paragraph 2.9 of GN 665. If you discharge of effluent that originates from a source on land into coastal waters, it's generally authorized, subject to quality and quantity restrictions, and it must be registered as such in terms of GN 2990. If you dispose of waste in a manner that may detrimentally impact on a water resource and you comply with the requirements of the authorization, you need not apply for a license, but you must register your general authorization in terms of paragraphs 3.11 and 12 of GN 665. If you alter the beds, banks, course or characteristics of a water course, again within this ambit allowed by GN 509 and GN 4167, then you must register such activities in terms of paragraphs 3 and 6 of GN 4167 and paragraph 13.1 of GN 509. If you remove, discharge or dispose of water found underground for the safety of people or for the effective continuation of operations, and you qualify for the general authorization, then you must register it in terms of paragraph 4.7 of GN 665. So the most important thing to understand about the general authorizations is firstly that the water use right is already granted by the general authorization by the gazetted notice. So you do not apply for a general authorization. The government granted general authorizations by publication in the Government Gazette, and they basically said to water users, if you comply with the conditions that we outline in the Gazette, then you do not need to license. We are satisfied that your water use is then lawful. But, and that but is in capital letters, you can only rely on these general authorizations as your legal entitlement to use the water if you comply with all the conditions, including the condition to register. So you may qualify on all the criteria outlined in the Gazette, but if you don't register and the department knocks on your door, you can't claim lawful use because you omitted to comply with one of the conditions, which is the condition to register. The department has to know about you, otherwise they are just back to the situation where they do not have a register or an indication of lawful and unlawful water use in the country. So having completed the first type of registration drive, the census, the next step is now to determine who are using the water legally, lawfully, and who are unlawful water users. So by registering in terms of one of the general authorizations, one or more of them, you are basically recording the legal status on their database, which will ensure that you do not incur penalties for unlawful water use. Other conditions, typical conditions of these water use general authorizations relate to monitoring, record keeping obligations, and as I mentioned, quantity, quality, geographical exclusions, and so on. So it's a complex inquiry to determine whether a specific water use qualifies for a general authorization. And this presentation does not try to address those complex issues. It merely alerts you to the different type of registration certificates. And as you can see, registration of your generally authorized water use, provided that you comply with all the other conditions, vests you with a lawful right to use the registered water. And that is the main difference between the census registration drive and the general authorization registration obligations. So let's look at a typical example of what such a general authorization registration looks like. It is not a certificate that resembles the first one. it is more resembling a letter confirming that the department has received your registration and that you may now proceed to continue the water use in accordance with the requirements of the relevant general authorization. So this is an example of a general authorization done in terms of the Section 39 of the National Water Act. This particular one related to the discharging of waste or water containing waste into a water resource through a pipe, canal, sewer or other conduit from a wastewater treatment works. Now you will see the letter from the Department of Water and Sanitation acknowledging of the above water use activity is confirmed, and a registration certificate will be forwarded to you in due course. Now, I haven't really seen the department issuing registration certificates, but most of them just issue this type of letter in which they confirm the water use, the property on which the use may take place, and then they remind you that you must fully comply with the conditions of the gazetted notice. And in this particular letter, they're attaching it as an annexure to the letter, and they draw your attention specifically to the record keeping and disclosure of information and inspection requirements. Failure to comply with the conditions may expose you to a penalty set out in terms of the National Water Act, and then a couple of administrative issues being communicated, the validity of the general authorization unless it's amended or the period is extended by notice in the Gazette, it's replaced by another general authorization, or the water user is required to apply for a license. That is, if the department calls on the water user to apply for a license. So a number of conditions imposed by this covering letter, and then, as I mentioned, attached the general authorization in terms of which this use may continue without a water use license, but subject to all of the conditions imposed by both the letter as well as the gazetted notice that contains the general authorization. So as I mentioned before, this is you can call it a type of a license. You don't apply for the license. The government has already published a generic license for these water users that you must comply with in order to avoid the expensive and time-consuming regulated water use license process. So let's quickly recap to see what we've learned up to now. These are the Section 21 water users that require registration as part of the database establishment, and this had to be done before the 10th of June 2023. It was a repeat of the 1999 registration attempt, which was not very effective, and a lot of the information has been lost. So unless any of these users are listed in the first schedule to the Act, they had to be registered. You will see that there are 3 water users that have not yet been the subject of a call to register, being Section 21C, I and K. Now, I think this is because these water users are fairly difficult to identify and quite complex, and I suspect that we will get in future another registration attempt for these water users. But for now, if you undertake one of these users, you did not have to register them, but that does not mean that you do not need to license them. So remember, we constantly have to separate the issue of legality versus registration. So these users had to be registered to get onto the National Water User Database. Then we also saw that of these Section 21 water users, a number of them qualify for general authorization subject to several conditions, one of which is the obligation to register the use. So again, you see that 3 water users have not been generally authorised, and unless qualifying for existing lawful use, continuation, or listed in the first schedule of the Act, these three uses require a water use licence in terms of the National Water Act. Okay, so now you have an understanding of the two different types of registration requirements imposed by the National Water Act and the purpose of each, but you still have quite a bit of work to do in order to identify whether your company still needs a water use license. So in this table, I just want to illustrate the considerations that you still have to go through. And in the first column, I've listed all the Section 21 water users that are identified by the National Water Act. Then you will identify your firm's water use by ticking the relevant boxes. And for each of those identified users, you will then consider whether the 2023 registration applied, and if so, whether you registered. If not, you need to still do so. Then the inquiry into lawfulness starts, and it starts firstly by determining whether a general authorization applies to the identified use. In this column, I have identified all the Section 21 water users that are subject to a general authorization, and you will then have to read the general authorization carefully to determine whether your water use qualifies in terms of quality, quantity, geographical location, and exclusions. If you conclude that it qualifies as a existing water, as a generally authorized use, then your inquiry for that specific water use stops there, and you know that it's lawful. You do not need to continue with your investigation. If, however, you go through the general authorization and you realize that no, you do not qualify, then you continue to determine whether that specific water use is listed in the first schedule. If you do not qualify for the general authorization, you will also not qualify for a first schedule use, and then you need to proceed to determine whether that use perhaps preceded 1998, and that you can demonstrate that you used the water lawfully for during a period of 2 years prior to the commencement of the Act in October 1998. And let's say your use commenced after 1998, or that you cannot demonstrate that you used the water, you stored the water during that period lawfully, then you will realize that you do not qualify for any of the recognitions of lawfulness other than licensing, and you will need to apply for a license. Right. Also take note that if you carry out one of the water uses that did not require registration, it does not mean anything in terms of its lawfulness. You still need to determine, is there a general authorization? Do you qualify? If not, was it a first schedule use? If not, was it an existing lawful use? If not, license required. Right. And the same for if there was no general authorization required or published, it means that the government does not exempt any of these Section 21D users from a license requirement, and you need to go through your survey of determining first schedule use, existing lawful use, and if the response there is no, a water use license is required. If the response to any of these are yes, it qualifies as a first schedule use, or yes, it qualifies as an existing lawful use as defined, the inquiry stops there and a water use license is not required. So this is an important process to go through. The most critical aspect, of course, is to effectively identify your company's Section 21 water users, and sometimes it is best to involve a specialist to assist you in that inquiry because of the wording that is not always so straightforward, and the understanding of the descriptions that are required to identify things like impeding or diverting the flow of water in a watercourse. Hydrologists are familiar with the types of activities that have such an effect on a watercourse, and it will be best to involve a specialist in this identification. As I mentioned during the presentation, the interpretation of the general authorizations are also not straightforward, so the specialist that you involved with the identification should also be able to help you to determine whether you qualify for general authorization. So last but not least, I also just quickly want to show you what a typical water use license then looks like. You will see it is clearly identified as a license in terms of Chapter 4 of the National Water Act in the heading. It is allocated a license number, and the details of the license used are then outlined in the cover letter to the license. The review period, the validity period, important definitions as a covering page, and then in Appendix 1 there are usually general provisions and conditions of the license. These are pretty generic for all water use licenses, concerns things like stormwater management, measurement, reporting, and so on. And then in the other appendices, the general conditions in this one is quite long. Let's just scroll down to the end of the general conditions. Then the remaining appendices outlines water use specific requirements, pumping rates, coordinates, volumes that may be taken, and so on, and specific conditions attached to this specific use, water measurement, water quality testing, and so on. Now this license is relatively short because it's only one water use that is being authorized, but for mining companies and larger companies who have more than one water use, these licenses can easily run into 40 or 50 pages, and then one needs to, of course, assign roles and responsibilities for compliance or establishing compliance with the water use license conditions, and that must be done from a very senior level within the company, followed by training in the water use license requirements, regular monitoring, document control aspects that require attention. So it's a significant, I don't want to call it a burden, but let's say it's a huge job to establish, maintain, and monitor compliance with the water use license. That brings us to the end of the presentation, and I think it's easy to see why there is confusion on the topic of water use registration versus licensing. So I hope the information equipped you to revisit your firm's water users and to conduct a survey, a water user survey, to confirm that you registered all the relevant water users and that you have also licensed the users that do not qualify for general authorization as an existing lawful use or a first schedule use. So good luck with the work, and feel free to submit any additional interpretation challenges that you may have to me via the submit your question function of the Act. Thanks for watching, and take good care.